Good morning all. We're here today for the continuation of the trial in the matter CFI 26-2012, Mustafa Al-Hendi versus Dubai Aerospace Enterprise, DAE Limited, before Justice Sir Anthony Colman. The claimant is represented by KVH Kanoon. Legal counsel is Bashir Ahmed, assisted by Luke Lane. The defendant is represented by Al-Tamimi. Lead counsel is Stephen Thompson, assisted by Fiona Campbell and Gordon Barr.
Right, good morning. We need to deal just with this application before we start the evidence. I've obviously read the pleading. Do you want to say anything about this, Mr. Thompson?
Yes, I do, quite a lot.
Well, I'm afraid you've got 5 minutes, so get going.
My Lord, what I say about this is that if you, my Lord, I'm going to have to take you to a couple of documents for this. I
don't think you need to refer to any documents. You've got the pleadings here. It's perfectly clear what the pleading says. Either it's permissible in the context of the trial at this late stage, or it's not. It's as simple as that.
Well, my Lord, if you're minded to exceed this application, I do stress that there are some significant arguments. There is one document in particular I will have to take you to. I understand your Lordship's concern about timing on this, but this is a very different clause from what we were presented with yesterday, and there are two arguments in particular that may involve you looking at documents. I'm not intending to trawl through many, many things and take the hours over this, but I was anticipating taking about 15 minutes. I hear what your Lordship says, and your Lordship is entitled to give it to me if you think this application is not going to proceed, but it's important.
Will you refer me to the document first, and then we'll go from there?
Okay. Well, my Lord, can I refer you? Can I give you an outline of what I'm going to say? You might tell me that some of the points you're already persuaded on. I don't want to hear them. Here we go. The first point, I won't take you to everything unless you tell me to in that case. Clause 18.10 in the contract says that a provision may be deleted or modified as necessary. So what we ought to be looking at, if this is going to be relied upon, is how the provision in the contract be modified as necessary, which must be an adjective which is tantamount to an implied term. It must be necessary, not just something that is desirable or seems a good idea. So the first point is, I don't see that this is any adjustment to the provision itself. What words, I ask rhetorically, in clause 8.2 are being modified here? None. And the answer, the reason, I say rhetorical, the reason that there's no words in the provision that are being modified is because actually what this is an attempt to plead that the operation of matters was different. Conduct, post-contract. That's the first point. As necessary, that's my second point. Is this necessary? Let's just ensure that that test is met as we go through considering this point. The third point is, on clause 18.10, that it refers to common intention. And I ask your Lordship, common intention when? It must be, in my respectful submission, the intention of the parties at the time they make a contract. Ex hypothesis, this amendment will not work then, because the performance appraisal system on the claimant's own evidence was something he devised. He devised it, obviously, after he started, and so it can't have been an intention of the parties that they use this system when they signed the contract, because it didn't exist. It can't be right that this means common intention of the parties as time passes, because that would be a license to rewrite the contract any time one felt like it. And that can't possibly be what 18.10 meant. It actually, my next point, lost track of numbering I'm afraid, my next point is, why is this clause in the amended particular claim, why is this paragraph here? Can we just look at the structure of this particular claim and see where it sits? Above paragraph 13 is the title, Breaches of the Agreement Leading to Termination. And we then have three clauses that deal with the car and housing allowance. The agreement is said to be breached in respect to those because the allowance was terminated. We know that, that's fine. The next clause, the new one, 15A, deals with setting targets, identifying and finalising MBOs. And it is said again, and this is 15A.3, that it didn't, the defendant didn't set targets. That is a material and fundamental breach. I'm ready and prepared to argue that that is wrong. That's the case. Then the new clause, we'll come back to that, and then there are other provisions that are said to have been breached in relation to the bonus, and it is said in 19, that each of the above breaches were fundamental breaches of the agreement, and so it is said he is entitled to terminate. Now look at the new clause. What's the breach? What's the fundamental breach that is pleaded, that is said to be something that entitles the claimant to terminate? There is no breach pleaded in there. That is a clause, the new provision, that says, oh, well, you can modify the contract. If it's a clause of how the contract ought to be modified, I could understand if it was in the section of this pleading dealing with the terms of the contract, but this is said to be a breach. Now, my learned friend might say, reply, oh, that's not a problem, Mr. Thompson's nitpicking, we can just shove that back to somewhere else. She's in the last chance saloon, I remind you, Lordship. I'm a bit bored of having to deal with her applications as a moving feast. My next point, which is the one which I would invite your Lordship to look at the document, but I'll tell you what it is, and your Lordship can make your own mind up. This is truly inconsistent with the case that the claimant has put in his evidence, because in his evidence he says, unequivocally, although I paraphrase, I created a performance appraisal system. Do not confuse this, he says, with the contractual provisions. Would your Lordship like me to take that paragraph?
Lima. Just yes, in the papers on the bench, newspapers, bring them in. Yeah, go on.
Shall I take your Lordship to the paragraph that says that, or shall I just read it?
Yes, go on.
It's tab 5 of C2, Mr. Al-Hendi's main witness statement.
Yes.
Paragraph 32.
Just hang on half a second. Let's get this. Sorry, which paragraph?
32, page 12.
Yes.
In November 07, I developed and launched a general performance appraisal system essentially to evaluate all employees' performance. This was seen as a tool to identify and retain competent staff. 33. This was a general performance appraisal system which was applicable to all employees regardless of any contractual entitlement to bonus, and is therefore not to be confused with the contractual entitlement of a limited number of high-achieving senior execs, including me, approximately 10% of the total number, whose employment contract stipulated additional terms providing for bonus and LTIP entitlements. 35. As such, the introduction of the newly developed performance management system did not in any way change, invalidate or supersede any of the contractual entitlements to bonuses and LTIP of those employees, including me. He says, in terms, this is something different. How then can he now plead a case which says it's what we used? And that brings me to the last point, my lord, which is actually what this is a pleading all about, and why it is a pleading which would require new evidence. If you look through it, and I'll take the lordship to the paragraphs to make this good if invited, if you look through the case before this amendment, you will see that the claim is predicated on the concept that MBOs weren't set and should have been, or that KPIs were used instead. Pausing there, that is a claim about the setting of targets. And what is said is that, and there are alternative analyses, but what is said is that they weren't set, that was a fundamental breach of contract. Alternatively, they weren't set, but the defendant effectively, by conduct, waived the need for setting of targets, and so the bonuses just become automatically payable. So that's a claim about setting of targets. But this clause is different, because this new clause is about using the performance management system. So it's actually about achieving the targets, which is a different thing. Achieving the targets is what you do a year after you set them. And that would require different evidence. And to make that good, I ask your lordship to think back about my cross-examination of Mr. Hendi. I can assure your lordship, I didn't take him to the performance management system documents that he created. I didn't ask him about his performance during the year. I didn't ask him about the 3.9 that Mr. Mustafa gave him in 2009. I didn't ask him anything about his performance as an employee against targets, because that wasn't his case. His case was that the targets weren't set. And, my lord, I say, in relation to evidence, my witnesses too have not given evidence, quite understandably, about Mr. Al-Hendi's performance over the year and how he was rated and what he was rated against. They don't go into that, because the case until today was about the setting of targets. Now, my lord, I can and I would, if you allow me time, take you through the pleading to make good my submission on that point.
I'm quite well aware of that.
Well, my lord, in that case, I think I've probably overrun the 5, but that's as quick as I can make it.
Okay. Yeah.
My lord, just to take those points in turn, the first one was clause 8.2 and what is the modification we see. My lord, without taking you to the agreement, the modification is by reference to 8.1.1.
Just have a look at that.
And I did say I didn't want to take you to the agreement, but I'm probably going to have to. It's in the core bundle. that one.
Sorry, the agreement, yes, I got that.
Yes, the agreement. The modification 8.1.1.
Yes.
So that would read, the executive shall be eligible to receive an annual cash bonus at the end of each employment year. The company may pay to the executive the annual bonus as follows: 8.1.1 up to 50% of the executive's annual salary if all pre-negotiated target management business objectives for the employment year are achieved, or the modification would read, or if the KPIs are achieved in accordance with the performance appraisal system or performance management system. And that would then be repeated 8.1.2. 8.2, again, the modification would read, the target MBOs and maximum MBOs for the employment year 2007 are set out in Schedule 2 to this agreement and are subject to final approval and agreement between the Executive and the Compensation Committee of the Board. Such final approval and agreement not to occur less than 90 days. And then for each category, the executive must achieve all of the target MBOs or all of the maximum MBOs in order to achieve the bonus, receive the bonus payout for that category, calculated in accordance with the manner described in Schedule 2. Alternatively, bonus shall be paid by reference to the achievement of KPIs within the performance management system. And again, that will be repeated for 8.5. So that is the modification. The modification is that where the contract provides for agreement of MBOs, where there is no MBOs agreed, then the defendant will look to the performance management system to evaluate and assess when a bonus is payable. That's the first point, my lord. The second point is in relation to necessity. My learned friend says that it's not necessary to modify the agreement in those terms. Well, we say it absolutely is necessary to give this relationship, to give this contract business efficacy. It's not a question of you have to look at the common intention of the parties at the time of entering into the contract. That is one analysis. However, clause 18.10 specifically must be there to deal with a situation when the contract has been performed differently to what was first envisaged when the parties entered into the contract, and then modify it or delete it in accordance with how the contract is performed. It cannot be said that a contract cannot be modified after it's been entered into. That's just absolute nonsense, my lord. The third point is, and I think that deals with the common intention point, the third point is in relation to where it sits in the pleading. Well, I do say my own friend is being picky and pernickety. Where it sits in the pleading, my lord, is after the provision whereby we say MBOs were not agreed, and therefore we say in the absence of MBOs not being agreed, there is a performance management system that is used, and therefore, my lord, we say that the relief we seek is after those relevant paragraphs where we set out why it is that we seek that relief. The fourth point that my learned friend made was in relation to the evidence, and that more evidence is needed, and that he didn't cross-examine the claimant, and so forth. My learned friend has referred you to the claimant's witness statement. And again, the evidence that you've heard, my lord, is rather murky in terms of what individuals mean when they say contractually eligible. I mean, for instance, Mr. George Mustafa can give I would submit, a satisfactory response as to what he means when he talks about class and category of employees. When one reads paragraph 35 of the claimant's witness statement, what it says, as such, the introduction of newly developed performance management system did not in any way change, invalidate or supersede any of the contractual entitlements to bonuses and LTIP of those employees, including me. I mean, it's always been the claimant's case that by virtue of clause 8, he has a contractual entitlement to a bonus. That's always been clear, and that's what paragraph 35 says. If my learned friend is now saying that he doesn't know, or he didn't know the case that the claimant was putting forward, well, in which case he needed to have read the witness statement properly. If one goes to paragraph 89, and I'm just picking that out because it encapsulates really what the claimant's case is. There are other paragraphs, for instance, 77, 78, 77 talks about a meeting whereby the claimant submits a list, tells the committee about the issues. And the 77.3, I explained that there was a difficulty in that not all employees had signed their MBOs for the second year. Paragraph 78, this represented a problem in relation to all those that had a contractual entitlement to a bonus. Some KPIs had been signed and approved whilst others had not. Again, it goes back to the claimant's understanding of his contract, which was, and it's in line with paragraph 35 that my learned friend criticises, that he, by virtue of clause 8, had a contractual entitlement. Some KPIs had been signed and approved whilst others had not. KPIs again makes reference to the performance management system. There was a concern in relation to the quality and consistency of those KPIs, and therefore there was no way of measuring the employee's entitlement. That fairly and squarely talks about the performance management system. Paragraph 79, December 2008, further guidance in relation to how performance should be assessed. And then we go forward. And this is the paragraph that I mentioned first, paragraph 89. And this is about when the claimant asks Mr. Mustafa about the ratings, and there aren't any ratings. Paragraph 89, following this, I received an email from him providing me with a rating of 3.9 and asking me to update the spreadsheet. I did not know where this rating had come from. No MBOs had ever been agreed or finalised with me 90 days from the commencement of my employment. I had an individual performance contract, which the CEO acting must have had, and which Mr. Bob Johnson had approved. This may have been used as a substitute for MBOs. Mr. Mustafa had been tasked to sit down with me and review my performance, given I was his direct report. However, this process had not taken place.
Well, this isn't a reply. I'll have to deal with all this if this is new.
Well, it's not new,
This
is
isn't
it?
a reply at all. This is an application. I haven't had a chance to think about any of these, but I can deal with it on the thing.
My Lord, I'm responding to my learner's friend argument.
Just go ahead.
Thank you. And so 89.5, my Lord, sets the evidence that in the absence of agreeing target MBO or maximum MBO within 90 days, given the inadequacy of the procedure that induced us to take my bonus, it was my view that as with the 2007 bonus, the defendant was in many cases treating all MBOs as met, even in the absence of any pre-negotiated MBOs. And then moving through the witness statement, paragraph 98. Again talks about the process involved with the IPC and performance management system. I don't need to read the whole of that out. Paragraph 113. Despite defendant's failure to follow any standard procedure, that being its failure to first agree MBOs within 90 days of commencement, failure to approve KPIs for employees, and not just some of them, provided a performance evaluation rating despite the fact that the CEO acting had failed to conduct a one-to-one performance review. So what he is saying, that there was a failure to agree MBOs. In the absence of an agreement of MBOs, the defendant looked to the performance management system to provide a rating to evaluate and assess a bonus. However, the claimant also says that even though that this process was in place, it wasn't followed properly. But that's completely different to say that the facts are not there and the defendant hasn't been aware of these facts as set out. And we say again that there are no new facts that are needed. There are no new witnesses that the defendant would need to call, particularly because Mr. Bob Johnson was never going to be called anyway.
Okay, thank you very much.
Thank you.
I shall not allow this application. In a word, my reason for doing so is that the claimant will either prove that the employment agreement was varied, or that the defendants are stopped from denying that a new system of target setting had been introduced and was to apply as between the parties. And if they fail on both those points, it seems to me there's no room for introducing the same result via clause 18.10. Accordingly, this application, as I say, will be refused. Yes, Mr. Mustafa. Good morning, Mr. Mustafa.
Good
You're
morning.
still under oath.
Yes.
Yes.
Mr. Michelle, can I ask you to take D3, please?
D3.
D3, yes.
Yeah.
Can I ask you to turn to tab 121, please?
Yes.
It's a letter dated October 15th, 2009. It's got your signature at the bottom, Mr. Michelle.
Yes.
Now, yesterday you gave evidence that the claimant represented to you that he was in a class of cash group of employees that was entitled to a bonus. Yeah?
True.
So, if you would have seen this letter, well, let me ask this question. Given it's got your signature at the bottom, you're not suggesting, are you, that you didn't read this letter and you signed it without reading it?
No.
So you read it and you signed it.
Yeah. Yes.
And
Yes.
so, sorry.
Yeah, go ahead. Sorry.
No? And so, I mean, it's not a case, is it, that you were duped into signing this letter, is it?
I'm sorry?
You were tricked into signing it?
No, tricked, no.
No. And it's not right, is it, to say that the claimant must have forged this letter or forged your signature?
No, this is my signature.
Because I don't know if you're aware, that's what the defendant is saying. The defendant is saying that this letter, you were tricked into signing it. That's not right, is it?
No, the content of the letter, again, this is the same basis for everybody else. This is the bonus and the LTIP payment, the 50% spread over two. So this one, for everybody else, there was, for everybody who was eligible for bonus at the time,
Yes.
was supposed to receive such a letter.
Yes.
So it was one of the class, the other employees.
Yes. And in fact, before you signed this letter, you had a conversation, didn't you, with Ms. Jones about the content of this letter?
With Mustafa and Leslie, both.
Mustafa and Leslie. And if we go back a couple of tabs, tab 120, please.
Yes.
This is an email from Ms. Jones to Bob Janice, CEO of Capital, and the claimant. To be printed on the headed paper of DAE or DAE CAP advisors. Now, the reason why that instruction was given was because the Capital employees, DAE Capital employees, their letter would go on a DAE CAP advisor heading, wouldn't it? Headed paper. Yeah?
The US employees.
Yes. And the DAE holding would go on a normal DAE headed
Yes.
letterhead. And if we read down, Bob, letter content, attached as discussed in the draft letter, I've made a minor amendment to seek to clarify the applicable payment reference, which as discussed is the terminology used in the contracts. To ensure the references are correct, I will prefer that we check each letter against the relevant contract and have to do this if you want to the contracts. Alternatively, I'm okay with you doing it. Let me know which you prefer. Similarly, the dates of the employment year reference should be changed to avoid any later confusion. Now, the letter, the content, that content was drafted by Ms. Jones, wasn't it?
As far as I remember, from both Mustafa and Leslie, they coordinated the effort.
But the first draft, if we read this email, is it not correct that the first draft was provided by Leslie?
I don't know if the first draft was provided, but the whole thing, the content was from both.
Okay.
Always. I
Now-
took advice from both of them.
You took advice from both of them. And you worked very closely with Ms. Jones, didn't you?
Like everybody else, yeah.
Yes. And she was the lady, she was the person who was advising you as to the contractual entitlement of these employees, wasn't she?
She should have, yeah.
Well, was she or was she not? She should have, I agree, but I'm asking you that she did.
I presume so, yeah.
Now, when you discussed with Leslie Jones this letter, I know you say you discussed it both with Ms. Jones and the claimant, but in discussions with Ms. Jones, was it your understanding that when drafting these letters she had looked at the agreements of the individuals?
I would assume so.
Well, that's fine. I understand why you would assume that, but what I'm saying is, was that your understanding that she had actually done that?
Again, I don't know what she did, but I would assume at the time she did.
And is that assumption because of something she may have said to you?
No.
I mean, in order to draft that letter, she would have to look at the agreements, wouldn't she?
Again, presumably, yes.
Going back to page 121,
Yes.
this is it's a letter confirming the annual bonus of 600,000
Mm-hmm.
to the claimant. Yeah, and that's for the 2008 bonus, isn't it? Year ending 2008.
Yeah, they will pay your annual bonus and it's on 600, yes.
Yeah, and then the second paragraph is in relation to the long-term bonus, and that was the decision to pay it in 2 tranches.
True.
And at the bottom is a provision whereby the claimant has to sign to confirm these payments. Yeah?
Yeah.
And the claimant didn't countersign it, did he?
As far as I remember, he did. I'm sorry, this one doesn't have it, but as far as I remember, maybe he didn't.
Maybe he did as
Yeah.
well.
But as far as I remember, everybody signed this one, and this was in agreement with everybody, including Mustafa, the approach.
But the claimant says he didn't sign it, and the reason why he didn't sign it is because he thought that the basis of calculation had been unfair, and he told you this, which is why you then went to the board to ask for an increase. Do you remember that?
The 600 is not the final one, yeah?
He was,
The LTIP is the same, I believe. Maybe. But there was a subsequent letter to this one?
no, but let me ask you this.
Hmm.
Do you recall going to the board for a recommendation that the board increase the annual bonus payment from 600,000 to 800,000? Do you recall that?
The board and the NRC, yes.
NRC, yes.
NRC, then the board.
Yes,
Yeah.
that's right. And the reason why you went to the NRC and the board is because the claimant came and told you that the calculation or the value of the bonus that was being paid was not a fair calculation. Do you recall that?
This was done again for Mustafa and 2 other employees.
Yes, and the 2 other employees were Feroz and Robert, weren't
Yeah, Bob Genies, yeah.
they? Yeah, and
Because, yeah.
but the claimant, what he said was the calculation that you've conducted isn't fair. That's what he said, didn't he?
I don't know, but what he said specifically at the time, but I remember going back and revising these 3 employees' bonus, and I went to the NRC and to the board later.
Yes. He never said to you, for instance, did he? Actually, I want the maximum stretch amount, so give that to me. He didn't say that, did he?
We never, I cannot specifically comment on this one, but in general, we never took the stretch bonuses for anybody,
Yeah. And
for all.
And what he said to you was, by reference to the other two individuals, Feroz and Robert, in some cases they had the same rating as him. So Feroz had the same rating as him. Robert had a lesser rating than him. But yet, relatively speaking, their bonus was higher than his.
Amount-wise or percentage-wise?
Percentage-wise.
Percentage-wise?
Yes.
Maybe, yeah.
Can I ask you to turn to D3125, please?
Yes.
And page 585.
Mm-hmm.
It's an email dated the 5th of November. Before we look at the contents of this email, so the claimant said to you that the calculation of my bonus is wrong by reference to the other two individuals, and you then took it to a meeting with the NRC, didn't you?
For the 3 employees, yeah, I presented to the RC. I believe it was a meeting, yes.
Yeah. And you wrote them an email on the 5th of November, that's the NRC committee,
Mm-hmm.
and we see that at page 585.
Mm-hmm.
Now, in terms of what you were telling your superiors, the NRC and the board, in terms of what you were telling them, you understood, didn't you, that any information that you had to provide had to be truthful and honest in your own account. Yeah? So, when you write to the NRC, you say at the top there about the additional amount. Please note that the differences may be due to compensating the top 3 performers in the organisation. And the top 3 performers, as you've said, is Feroz, Robert and the claimant.
Mm-hmm.
And you must have believed that they were the top 3 performers. Did you?
Yes, I believe so.
And so they were, if I can put it fairly, they were the top 3 performers of the company.
DAE holding, yeah.
Yes. And you also write to them telling them Mustafa plays a pivotal role in DAE. The reason why you write that is because he did play a pivotal role, didn't he?
Yes?
And you also say his performance last year led to saving DAE millions of dirhams, whether in terminating several unjust employment contracts, professionally handling the exit of the ex-CEO, in addition to management of the whole employee settlement of DAE University. And taking those in turn, what do you mean when you say terminating several unjust employment contracts? What's unjust? What do you mean?
Again, there were lots of contracts before my time that had some outrageous maybe clauses not in favor of the company. So Mustafa handled all of these people.
Yeah, and you thought
You can check the people who left the company from 2008 and you would know that Mustafa handled all of these
and you also did
contracts.
a very good job.
Yeah, in saving the company millions, yeah.
Yeah. And again, professionally handling the exit of the ex-CEO, the management of the whole employee. So, in the round, you thought that he had performed brilliantly. Now, you said yesterday 3.9 was a very good rating. 3.9 out of what? 3.9 out of
5.
And that rating, or rather, you were permitted to give that rating through the performance management system, weren't you?
Yeah, when he asked me to do it through the Excel sheet, yes, I filled it up for everybody, for
Yeah.
my direct reportees.
So when you write this email, the NRC come back with certain questions, page 584.
Yes, I see that.
Yeah? And they ask you to elaborate if there is any contractual obligations to pay out any performance-based bonus for the subject individuals. Second question they ask is, can you confirm that all relevant levels of management have followed the approved performance review process applicable to all employees? And then the next question is, if the above scenarios are met, it's understood and commonly noted that most employees' disputes are related to overall ranking and not the absolute bonus amount to every individual. This typically addressed through applying a pre-approved specific ratio of bonus pay hit. And in 3 particular cases, we can assume the above 2 conditions are met, and you have a pre-approved criteria for calculating the payout for an individual. The third scenario is applicable and was met, then why the same is not reflected in the original request. The questions start DEF. I mean, do you know if there's any reason why they start that? I mean, was there an ABC that you can remember?
Again, I'm sorry.
The email is, the points start DEF. Was there an ABC at all?
I don't know, I'm sorry.
Okay. Now, what this email is asking you is if there is any contractual obligations to pay out any performance-based bonus for subject individuals. The second one refers to an approved performance review process. The approved performance review process is by reference to the performance management system, isn't it?
Approved performance review process, yeah.
Yeah.
Applicable to all employees.
Yeah. Your response is on page, starts at page 583.
Yes, I see.
Yeah. Now, before you sent this response, it's right, isn't it, that you had a conversation with Mr. Al-Hendi about what you should write in response to queries raised by the NRC?
Yes, I took guidance from on the response even.
I beg your pardon?
I took guidance from him on the response.
Yeah, you took guidance, and you sat down, you had a conversation, and then you asked the claimant to assist you with drafting the response.
Yes, usually I do that.
Yeah. And is it fair to say the reason why you asked for his assistance is because, as you said, you're very busy, companies in crisis mode, you're here, there, everywhere.
And he knows,
Firefighting.
and he knows better with HR issues.
Yeah. And so what this response, your response that you send in your name does, it really encapsulates the discussion that you had with Mr. Al-Hendi, doesn't it?
I would, definitely, the practice was Mustafa would have given me some sort of a draft, and I would have made some changes and then send it.
Yes, because there are some changes in this, and so you're not going to send something out in your name unless you're absolutely satisfied with the contents of it, are you?
Yeah, usually I review that and send
Of
it.
course. And if we look at the response that you did send out, as you no doubt aware, and as explained in the DAE HR committee meetings, our recommended bonus payout for you 2008 were all for employees that have specific contractual bonus clauses in their employment contracts. Again, when you refer to specific contractual bonus clauses in employment contracts, you were making reference to, were you not, a clause 8 type provision.
I don't know, usually I reviewed the emails, but I didn't go back to the contracts themselves.
Well, you say that, but let's look at your next sentence. Please let me know if you're required to review these contractual clauses. Now, I know you said yesterday that around November 2010 you looked at the claimant's contract. Because you've written here, you're required to review these contractual clauses, one would assume that you yourself have already reviewed those clauses, and that's why you're inviting the NRC to review them.
No. If they did, I would ask Mustafa to provide the details.
And so you say that you definitely did not review those contractual clauses?
Yes.
B. The last sentence. Unfortunately, these targets were not always the most appropriate to reflect the desired performance. However, considering that they have already been approved by the group CEO, they constituted a contractual obligation with DAE which had to be upheld. Now, just dealing with that contractual obligation, you knew, didn't you, that the approval that had been given by the previous CEO, the claimant had expressed concerns about that approval to the NRC and to you?
The approved by Bob Johnson.
Yes,
Yeah.
yeah, we went through this yesterday.
I remember, yeah, August we discussed it.
Yes, exactly. And it also, or what had also been suggested is that in relation to that approval, there ought to be a session to validate and set up meaningful KPIs.
This is what the minutes said, yeah.
Yeah. And so, when you said it constituted a contractual obligation, was that because, having known that there were concerns about the previous approval, you understood that the defendant was obliged, under the contracts of employment of these individuals, to pay a bonus?
Yeah, so it was a contractual obligation, and as far as what Mustafa says, if we don't pay, it would have implications on DAE.
Yeah. The next paragraph, the performance review process was initiated by our HR unit at the end of year 2008. And all employees were evaluated. So you're saying that the employees were evaluated, and then again, that's by reference to the performance management system, isn't it?
Yes, I assume so.
However, bear in mind that the evaluation was based on goals that are most extraneous. We do not place great significance in the evaluation exercise. I have endeavoured to follow the process whenever the situation permitted. And, if we go to the page, in the three particular cases, I had numerous discussions with each individual and can confirm that my recommendations are based on an in-depth and factual evaluation. And you accepted yesterday that in fact you did conduct an in-depth and factual evaluation, didn't you?
Yes.
Our earlier recommendations were based on payment at target level. However, upon further reflection, it transpired that there was a case for awarding level between target and stretch level. So you believed, and that's why you were telling the NRC, that there was a case for awarding Mustafa, or the claimant, level between target and stretch target.
Yes.
And then you also say that, kindly note, 2 of these employees have not received any bonus payments since joining DAE, despite having now completed more than 2 years with the company. So, in terms, you thought that it was only fair that they should now be paid a bonus given their 2 years loyal service to the company.
Yes, as long as it's contractual and for everybody else. True.
Yeah.
Yeah.
And you say, I'm at your disposal to discuss further the targets and achievements of these 3 employees. So this advocating on behalf of the claimant, that was completely independent and it came from you, didn't it, yourself?
Based on discussion with Mustafa, yes. But the content of the performance, I stand by it. You know. At the time, Mustafa, Feroz and Bob did a good job.
Yeah. And what the board says, sorry, what the NRC says to you, the HR committee, page 583. Thank you for sending the clarification email since the committee has previously approved an amount of 6 million as per your recommendation. Since the extra amount is an exception, therefore we request you to take this to the board for their approval.
Yes.
Can I just get something clear in my mind, Mustafa? Your 3.9 rating, how does that fit in with all this?
In my opinion, it's a good, very good evaluation.
It was a good evaluation. You've said that. 3.9 out of 5 obviously was very good. I mean, it's nearly 80%.